So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital revolution. Today we're going to be talking about how your rights under the union really don't matter. And this is sort of a sad reality. Your rights don't mean anything to the government. And we're going to go to Massachusetts highest court on March the 30th. They ruled that the city of Boston had the right to require municipal workers to get vaccinated against the COVID-19 virus. And this was a loss for three of the unions in the police and fire unions in Boston, who argued that they had the right to bargain, that Boston officials had the right to bargain before implementing the policy. And we'll talk about it a little bit later on, but this is a right that unions have for everything. You have the right to bargain over how policy is implemented and whether or not management rights apply. And the 25-page opinion of the justice says, well, they don't need to bargain with the city's union before implementing it. Why? Because reasons. Given the unique circumstance and its threat to health and safety of the public, it was a non-delegable policy decision that could not be subject to the decision of bargaining because any such requirement would have impinged directly on the defendant's ability to provide essential public safety services. Now, to remind you here, these employees had been working under had been unvaccinated for a while, right? Yeah, these employees had been unvaccinated for at least a year, 8 months before the vaccine mandate was put into place. I'd have to go look. It really doesn't matter. But these employees were unvaccinated and risking their lives for, at minimum, 7 months. So there is absolutely no evidence that it would have impinged directly on the defendant's ability to provide essential public safety services unless those safety services were failing. But there's no evidence that there was. And you can go look at the records with respect to responding in the city of Boston. There's no evidence of that, right? So and to answer my question previously, the vaccine mandate was implemented on December of 2021. What that means is that for roughly 21 months, the employees of the city of Boston were not vaccinated, and there was no detriment to providing essential public safety services. It's absolutely insane. And, the union plaintiffs filed a motion in 2022. The Superior Court denied it, and then a single justice reversed it, restraining the city of Boston from enforcing its vaccine mandate in February of 2022. That is congruent with National Labor Relations Act. And it says, well, the court's decision in no way impacts the recent agreement between Local 718 and the city, and the COVID-19 mandate remains unenforceable. Ultimately, it does impact the recent agreement because it means that the government can do whatever they want, whenever they want, and abuse labor rights and abuse the union. And so it's very clear in this regard as far as I'm concerned. And I want to give you an example of what must be governed over and how sort of minute and fine these details are. So real quick, so they have to at least discuss with the union how the mandate will be put in place. Likely the government has management rights of some sort that do allow them to put into place their policies such as these, right? There is that ability for the federal government to do that. However, you have to bargain over how it's going, how it was put in place. And so we'll speak here to something that happened in March of 2016. This is from Westlaw. And in this, Columbia College of Chicago in March of 2016 decided to reduce credit hours in several subject areas, right? So as a college, it's reducing credit hours in several subject areas. And as a result, some part-time faculty employees weren't able to work as much, and as a result, they were either laid off or they didn't or were paid less. So this is a college deciding to reduce the amount of hours that you need to graduate. So not really directly affecting the union. And the National Labor Relations Board unequivocally held that the college needed to engage in the effects of bargaining. And it's absolutely, I say unilaterally, that it wasn't unilaterally, but the board held that they did need to engage in the effects of bargaining. This is sort of very indirect, right? This is not particularly specifically at the union. The city of Boston said your union rights don't matter under the National Labor Relations Act. Now, it's absolutely absurd to me. It's not held by any law. It's not held by any reasonable considerations that we know of. It's absolutely frustrating and belies the meaning of the National Labor Relations Act and unionizing as a whole. What do you think about today's video? Please comment down below, like, share, and subscribe. It really helps out. And I'll see you on the next one. Bye, guys.